Good morning, Wabash. Today, giving our talk will be the Himsels. The Himsels are lawyers who are fascinated by the issues that arise when law and religion collide. In addition to teaching part-time at Wabash, Professor Himsel practices law at Faegre Baker Daniels, including representing religious organizations in a variety of contexts. Ann Himsel practices law at Littler Mendelsohn, where she is a national subject matter expert in advising employers on how to accommodate the religious beliefs of their employees. The Himsels are very active in the Wabash pre-law program, and they attend the Episcopal Church of All Saints in Indianapolis. Here giving their talk, Can a Corporation Break the Law Because of Its Owner's Religion? A Tale of Birth Control, Abortion, Obamacare, and Religious Freedom, the Himsels.
Our story today begins with an evangelical Christian baker in Colorado who refused to bake a cake for a gay wedding. The state of Colorado fined him, ordered him to bake that cake, and to fill the orders of all future gay customers under a state law prohibiting all businesses open to the public from discriminating against customers on the basis of their race, gender, or sexual orientation. Wedding cakes make up a huge portion of his business, so if the state's order could cause him to have to close, if he doesn't forsake his religious beliefs. Did Colorado reach the right decision? Or how about a large corporation like Hobby Lobby, a nationwide chain of 500 arts and crafts stores with more than 13,000 employees? The evangelical Christian family that owns Hobby Lobby refused to provide insurance coverage to its employees that would permit them to choose forms of birth control that the owners consider to be abortion, even though Obamacare required that coverage. Last summer, the Supreme Court ruled that the company's owners do not have to provide that coverage because of their religious beliefs. Is that the right result? When law and religion collide, which should prevail? More specifically, what does it mean? What does it really mean when our law says it will not impose a substantial burden on the free exercise of religion? For example, can a corporation like the bakery or Hobby Lobby, which is operated to make a profit, have religious beliefs? Can a corporation exercise religious beliefs? And if so, is it a substantial burden on the religion of the owners if the employee, rather than the owners, select the birth control that she will use? And finally, if Hobby Lobby can refuse to follow the law requiring coverage because of its religious beliefs, can other for-profit companies refuse to follow laws such as those banning discrimination against gay Americans or other protected groups, because of their religious beliefs? These questions illustrate the value to me of a liberal arts education, because analyzing these questions require knowledge not just of religion and political science, but also history, economics, biology, logic, language. In the liberal arts spirit, we won't attempt to answer these questions for you, but we believe the liberal arts tools can help us think more effectively about these difficult questions. So let's take it from the top. Political philosophers have disagreed for centuries about whether law or religion should prevail when they conflict. In the 17th century, John Locke sought to avoid further bloody upheavals in the battles over England's throne. So he sought to separate very clearly what he called the true business of religion, the life of the world to come, the salvation of our souls, from the business of government, which involves our money, property, and possessions. It's a great theory, but there are difficulties in its application because we use our money, our property, and our possessions to practice our religion. But given Locke's goal of separation, he strongly opposed any exceptions from the law on account of religion. The law should prevail when it conflicts with religion, according to Locke. James Madison disagreed. He was reacting against the beating and jailing of Baptist ministers by Anglicans in 18th century Virginia. Madison believed that when law and religion conflicted, religion should prevail, and you should get an exception from the law. Judge John Noonan calls this the radicalness of Madison, to suppose that an individual has a zone in which he or she responds to the voice of God, a voice beyond political authority. Madison thought his theory would work because he believed the voice of God would not often be heard in distorted or eccentric ways. Does that theory work? Given his belief, Madison's First Amendment, and he wrote it, provides that it protects not just our religious beliefs, but our free exercise of religion, our actions. I give you that introduction because the Supreme Court has zigzagged over the years between Locke and Madison. For example, in 1879, the court rejected a Mormon request for an exception to the law against polygamy, because such an exception would permit every citizen to become a law unto himself. Sounds like Locke. But in 1972, the court granted the Amish an exception from the law requiring high school attendance, because that threatened destruction of their religion, which requires separation from worldly society. Sounds like Madison. But in 1990, the court denied a Native American an exception to use the drug peyote, even though it was a sacrament of his faith, saying that granting such exceptions would be courting anarchy. Sounds like Locke. But the idea of exceptions to the law for religion did not die in that 1990 court decision. Far from it. The Smith case unleashed a firestorm of protest, and it produced one of the weirdest coalitions in American political history, including both the National Association of Evangelicals and the American Civil Liberties Union. You'll never see them together again. In 1993, this odd coalition lobbied Congress to pass the Religious Freedom Restoration Act. Now, come on, who can vote against something that's titled that? The Religious Freedom Restoration Act. RFRA is fascinating. RFRA provides a built-in religious exception to every law that Congress has subsequently passed, unless Congress says otherwise, and it never does. RFRA adopts the test the Supreme Court used in the Amish case, and here it is. If a person proves that the law imposes a substantial burden on the person's free exercise of religion, the government must prove that law furthers a compelling state interest by a means that is least restrictive of religious liberty. Otherwise, you get an exception. Sounds like Madison. The only thing I can think of that would make this long struggle over free exercise worse would be if it collided with Obamacare, a statute that some believe to be the work of the devil. That collision happened because Obamacare requires an employer's health coverage to include forms of birth control, like 2 types of IUDs and the so-called morning after pill. These medications are sometimes necessary for purposes other than to avoid pregnancy, including treating illnesses, and they can be very expensive. An IUD can cost $1,000. Here's the rub. These means of birth control can avoid pregnancy by operating after fertilization of an egg. Current federal law does not treat these techniques as abortion because it defines pregnancy as beginning at implantation. But the Green family that owns Hobby Lobby believes that they are abortion because their religion defines life as beginning earlier with the fertilization of an egg. So there's the conflict between the law and the free exercise of religion. Or is it? Can the Green family really exercise its religion through a corporation operated to make a profit? None of the cases I mentioned earlier involve for-profit businesses, and indeed, prior to Hobby Lobby, the Supreme Court had never given a for-profit business a religious exception. And in rejecting Hobby Lobby's claim in the court below, a judge observed that corporations do not pray, they do not worship, they do not observe sacraments. Others have cited Jesus in the Sermon on the Mount. No one can serve two masters. You cannot serve God and wealth. But Justice Samuel Alito, speaking for the court's majority, said that the modern American corporation was simply a form of organization used by human beings to achieve desired ends. And while those ends include making a profit, Hobby Lobby's statement of purpose commits the Green family, which owns 100% of the company, to honoring the Lord in all they do by operating the company consistent with biblical principles. Indeed, Hobby Lobby closes its stores on Sunday, although that causes it to lose millions annually. Refuses to engage in profitable transactions that facilitate alcohol use. Contributes some profits to Christian missionaries and ministries, and takes out newspaper ads seeking to win converts for Jesus Christ. Justice Anthony Kennedy agreed. Free exercise includes, and listen carefully, the right to establish one's religious self-definition in the political, civic, and economic life of the community, and acknowledged that the Greens deem it necessary to exercise their religious beliefs within the context of their own corporation. Justice Ruth Bader Ginsburg vigorously disagreed. She noted that to her it made sense to grant exceptions to nonprofit religious corporations because they include only persons who have already agreed to follow the same religion. But the 13,000 Hobby Lobby employees do not all follow the same religion. Indeed, federal law prohibits religious discrimination in hiring by a for-profit corporation that has more than 15 employees. Justice Ginsburg was concerned that the Greens were imposing their religion on its employees. In balancing the rights of the Greens and their employees, the Supreme Court ruled for the Greens and Hobby Lobby. Did the court reach the right decision? Should you be able to practice your religion through your business in this manner? Even if the answer is yes, remember that RFRA also required the Greens to prove that Hobby Lobby imposed a substantial burden on their religion. Now, setting the balance between law and religion is very difficult, and our law has always required the burden on religion to be substantial before granting an exception. Recall that Madison sought to protect men who had been beaten for preaching the gospel, that the Amish feared the destruction of their religion, and that RFRA itself was born in response to a law that prohibited a sacrament. By contrast, Justice Ginsburg argued that all Obamacare required was to pay money into an insurance fund. Justice Ginsburg believed this was a far cry from a substantial burden because the law didn't force the Greens to choose a form of birth control that violates their religion. Rather, the employee makes that choice. But the court's majority disagreed. It said the case raised what it called a difficult question of religion and moral philosophy. When is it wrong for a person to perform an act that is innocent in itself, paying money into an insurance fund, but has the effect of enabling or facilitating the commission of an immoral act by another, the employee selecting the morning after pill? And the majority concluded that it was not for the court to say that the Greens' religious belief that they were being required to enable sinful behavior was mistaken or insubstantial. Now, Justice Ginsburg acknowledged the court has long held it can't determine the plausibility of religious claims, but she argued in dissent that the court's holding had the effect of removing RFRA's requirement that the Greens prove a substantial burden on their religion. This brings us to our final question. Will the Hobby Lobby decision have a big impact in this country? Both sides in this dispute were screaming at the top of their lungs that Hobby Lobby would have a huge impact. But is that really true? That's the toughest question of all, and so I'm going to let Jane Ann handle it.
Thanks, I guess. First, some additional context. On the 4th of July, when I hope most of you were, at least those of you who were of age, were enjoying a beer and a hot dog and watching some fireworks, we were sitting on our back patio talking about Hobby Lobby for hours. Scott had on his professor's hat, and he was talking about Locke and Madison and dissecting the opinion in the way he would like to talk to you about it in his religious freedom class. Unfortunately or not, my space in the world is far more practical. I'm a management side employment lawyer, which means that employers, mostly secular employers, look to me, and fortunately my 1,000+ fellow lawyers at Littler Mendelsohn, to give them practical advice about decisions like Hobby Lobby. I was particularly on the hot seat for this decision because I devote a large part of my practice to religious accommodation issues. So I came into that holiday weekend discussion fresh off spending a whole lot of time with 3 of my colleagues putting together Littler's article on the decision. And if this speech, God forbid, leaves you wanting more about the technical details of Hobby Lobby, you can find those by Googling Himsel and Hobby Lobby. There are papers out there for you to read. Put that aside. The Hobby Lobby decision's not yet a year old, so predictions are hard to make. Here's what I can say at this point. For better or for worse, Hobby Lobby has caused a wider group of people to think and talk more about issues of religious accommodation and religious freedom. First, as of December the 17th, 2015, 26 additional non-religious private corporations had obtained rulings exempting them from Obamacare's contraception mandate. In other words, as of that date, 26 more companies located all over the United States with varying numbers of employees are planning to do exactly what Hobby Lobby is planning to do with regard to their employees' birth control choices. And while large publicly traded companies are very unlikely to be able to fit within the Hobby Lobby exception, their shareholders just simply won't agree on religious belief to an extent that the company could speak with one voice. Recent statistics tell us that up to 52% of Americans are employed, 52% of working Americans work for businesses that are closely held. In other words, they work with businesses that are potentially have a small enough number of owners that they might be able to convey through their corporate documents and procedures a concrete religious voice for the corporation. We don't know how many of those companies will eventually seek an exemption from Hobby Lobby. An exemption from Hobby Lobby, an exemption from Obamacare, akin to the one given in Hobby Lobby. Okay. Second, at least one court has relied directly on Hobby Lobby in a decision that has absolutely nothing whatsoever to do with birth control. In September of 2014, a federal district judge in Utah granted a RFRA-based religious exception to a member of the Fundamentalist Church of Jesus Christ of the Latter-day Saints, which allowed him to refuse to comply with a subpoena. Now, just so you know, the sect to which this individual belongs is a narrow group. They practice polygamy. They are absolutely not part of the Mormon Church, the Church of Jesus Christ of Latter-day Saints, okay? In this case, the Federal Department of Labor had subpoenaed this particular individual to testify in an investigation of potential violations of child labor laws that involved children from his religious group. He said he couldn't testify because he had vowed to keep the practices of his religious group secret. What's troubling is that in its application of federal RFRA, the federal district court, relying on Hobby Lobby, and you know what I'm going to say, really didn't require the individual to prove that providing the requested information to the government would place a substantial burden on his exercise of religion. Okay. In addition to these direct applications of Hobby Lobby has unquestionably spurred what the New York Times recently called the wedding wars that are going on across the country. Like the Colorado baker Scott mentioned earlier, other small for-profit corporations have refused service to same-sex couples who are planning their wedding celebrations. Those who have recently reviewed service to lesbian and gay Americans include a florist in Washington State, a bakery in Oregon, an inn in Vermont, and wedding chapels in Idaho and Nevada. The owners of these businesses seek a religious exemption from what we call public accommodation laws. Public accommodation laws prohibit businesses that open their doors to the public from discriminating against customers who are members of certain legally protected groups. Over the last decade, and legally protected groups, normally what you think of probably there is sex, race, religion, national origin. That's what kind of things we're talking about. So over the last few years, 21 states and the District of Columbia have added sexual orientation to their public accommodation laws. You can't discriminate on people providing a public accommodation on the basis of their sexual orientation. The federal government nor the state of Indiana have gone that far. The owners of these small corporations make an argument similar to the Greens in Hobby Lobby. It's not a sin to bake a cake, arrange flowers, provide an inn or a chapel, but when the state, through its public accommodation law, forces these businesses to provide such services for a gay couple, they believe the state is forcing them to facilitate gay marriage, which they believe is a sin. So the government, through the application of the public accommodation law, is forcing these folks to sin by providing this, when they force them to provide the service. Will Hobby Lobby enable these corporations to get an exemption from public accommodation laws? I think it will be difficult, but the answer is absolutely not clear. The New Mexico Supreme Court has already rejected such an exception. There's an excellent argument that anti-discrimination laws are different than Obamacare. So Hobby Lobby may not apply at all. Okay, back up. Recall that under RFRA, no religious exception is required from a law if the government is using the law to advance a compelling state interest in the most narrowly tailored manner. In Hobby Lobby, the Supreme Court concluded that the government had not met this requirement. While the court assumed that providing women with reproductive health care was a compelling interest, it found there was another way to advance that interest without violating the corporate owner's religion. Make the insurance company pay for the contraceptives. Don't charge the employer, make the insurance company pay. The court advanced this on the theory that the insurer would save money. They'd be willing to do it. They'd save money because contraception always costs less than pregnancy and childcare. That's the court's view. Moreover, Obamacare already gave that exception to religious denominations and non-for-profit religious corporations, and the court reasoned it could also be extended to for-profit corporations like Hobby Lobby. But the anti-discrimination laws, both public accommodation laws and employment laws, are different than Obamacare. There's no more narrowly tailored way to fight discrimination than to have a law that bans discrimination. I don't know how you get it more narrow. Okay. So the wedding warriors' attempts to use federal and state reference to avoid the implication of anti-discrimination laws may well fail. Indeed, Justice Alito made that argument in Hobby Lobby itself. However, when he made that argument, he used the example of discrimination based on race and not sexual orientation. Would the Supreme Court view stopping discrimination against gay Americans who want to get married as a compelling state interest in the same manner as stopping race discrimination? This is still more of an open question. 4 members of the Supreme Court, including Justice Alito, have been very critical of attempts to argue that our federal Constitution prohibits laws banning same-sex marriage. Justice Kennedy has been riding on the fence on the issue. As most of you probably know, the majority of the federal courts of appeal have ruled in favor of allowing same-sex marriage. The Supreme Court is going to answer this question in a decision that will be due sometime around mid to late June. And here I feel compelled to say that I hope July 4th, 2015 finds me celebrating with my LGBT friends rather than sitting on my patio with my husband dissecting an Alito opinion. But I digress. There's some other impacts of the Hobby Lobby decision you need to know about. Individual citizens and some state legislators appear to be trying to apply Hobby Lobby's principles outside of their original context. I'll give you 2 examples quickly. First, just a week ago, the New York Times reported that state legislators in South Carolina, North Carolina, and Utah have introduced bills in their general assemblies that, if they pass, would permit local government employees to refuse to issue marriage licenses to same-sex couples if those employees as individuals object to doing so on the basis of a sincerely held religious belief. Okay. If those state statutes are inconsistent with federal court orders permitting gay marriage, they'll likely have a very short life. But again, we don't have a final answer on gay marriage, and we won't have one until sometime in June. Okay. Second, and I'm coming to the end of my time, and this is where it gets really, really complicated, so bear with me. There were efforts in a number of states last year to expand state reference in ways, these are state laws that are modeled on the federal law, in ways that arguably would have allowed employees of private sector employers to unilaterally, on the spot, refuse service to customers on religious grounds if doing so would violate their religious beliefs. Let me give you some context for this legislation. Okay, first, Title VII of the Civil Rights Act of 1964, that's the big federal anti-discrimination statute, allows employees to seek accommodations from their employers for religious beliefs and practices. Employers are obligated to provide some reasonable accommodation so long as providing such accommodation wouldn't create an undue hardship on their business. For example, I'm not picking on bakers here, but for example, if an employee in a grocery store bakery who's an evangelical Christian felt his belief system prevented him from taking wedding cake orders from gay couples, he could tell his employer that. He could ask his employer to exempt him from taking the orders. If it's a big bakery with a lot of employees, the employer could probably reasonably accommodate him by exempting him from taking anybody's wedding cake orders at all. Okay? Special privilege, arranged in advance through a discussion that fits the context, that doesn't place an undue burden on the employer's business and is never actually communicated to the public. Nobody is offended. He just says, Mary Lou takes all the wedding cake orders. And he says it to gay people. He says it to straight people. He says it to anybody who wants a wedding cake. Okay. If the employee worked, and this is the concept of undue hardship, if the employee worked in a very small, very busy store that spent most of its time taking wedding cake orders, maybe they couldn't accommodate. Maybe there wouldn't be a reasonable accommodation that wouldn't place an undue hardship on the business. But there is nothing in Title VII that would protect an employee who, without any notice to his employer, decided he was simply not going to take an order, and he was going to tell the people who walked into the store, I'm not taking your order because my religion prohibits me from supporting gay marriage. Title VII doesn't protect the guy who does that. It just doesn't. There has to be some kind of notice and some kind of a dialogue about accommodation. All right, second, just to be absolutely clear, RFRAs are about governmental action. The government, whether state or federal, has to be placing the government, not a private actor, the government has to be placing the substantial burden on the individual's religious exercise. You can't use a federal or any existing state RFRA to sue your private sector employer if you get fired, okay? But the state RFRAs proposed across the country last year, which varied widely, contain language that, one, reached private action as well as state action, and two, flew directly in the face of the religious accommodation principles in Title VII. Some of the laws would have allowed the cashier, in my example above, to refuse to take the order on the spot. Others would have allowed him to sue his employer if he did that and his employer fired him. Others would have even allowed him to sue his immediate supervisor or the HR lady who fired him in that circumstance, even though those people can't be sued under Title VII, no individual liability. Okay, all that was introduced last year failed. I'm getting there, bear with me, to become law except one, and that was in Mississippi. That happened in large part because big corporations fought these laws. Big publicly traded corporations like Apple and AT&T. In part because they didn't want additional exposure, of course, but more importantly, they didn't want to promote any sort of discrimination against the LGBT community. And the Title VII religious accommodation principles, in their minds, were already working to provide the necessary religious accommodation. These people take their accommodation obligations very, very seriously. Trust me, I talk to them. They do. They really do. Okay, but simply put, discrimination is bad business. And they saw these laws as promoting discrimination against the LGBT community. Okay, so if all of this failed, except every place in Mississippi, why am I even talking about it? The final version that Mississippi adopted turned it back into a normal RFRA. It includes only, in Mississippi, the law includes only governmental activity and specifically excludes any right for private sector employees to sue their private sector employers. But just last month, a RFRA bill was introduced in the Indiana General Assembly that would, as it is currently drafted, reach private action as well as governmental action, and perhaps would even allow my bakery worker to sue his immediate supervisor or another company manager if he was fired for refusing to serve a customer on religious reasons, on basis of religious reasons. Okay. These issues are important. They're very recent. They're very near to us. As Scott said, and I'm sorry, I know my bias shows, but we are absolutely not here to tell you what your opinion should be about these issues. Instead, and this is the purpose of the college as a whole, is to give you an education and enable you to form your own opinions. But I do want to make one plea to you, and that is, please, 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 regardless of what you believe or don't believe, seek to be religiously literate. And let me tell you what I mean by that. I spend a lot of time talking to very smart, very sophisticated people, some of them religious, some of them not, and they know very little about religious customs. They speak very little religious language. And so when employees come to them seeking a religious accommodation, they don't have a context in which to receive that request. So again, I'm not telling you what to believe. I'm telling you, you have an absolutely amazing religion department here. Take advantage of their offerings. Learn what religious terms mean. Learn what people believe, because religion is going to remain, it is and it's going to be an integral part of the fiber of our society. And the more you know, the better equipped you will be to lead and to lead humanely, which is the goal of every Wabash man. Thanks.
All right. This Friday, track is away at Illinois Wesleyan, and basketball is away at Hiram. TGIF will be held at Fiji, 4:30. This Saturday, we have a lot of Wabash men away, with tennis at Oberlin, track at Olivet Nazarene, wrestling is at UIndy, lacrosse is at Center, basketball is at Allegheny, and then back here on campus, the Improvised Shakespeare Co. will be in the Fine Arts Center at 8 o'clock. Please rise and sing Old Wabash. From the hills of Maine to the western plains.